Davidson, and I'm discussing trust abuses. And in particular, in this video, I'm talking to the have-nots. These are the people who have been removed from the estate plan somehow. So maybe there was a trust amendment that disinherited you, or there was a whole new trust created where you were excluded. These are the people who simply are no longer named in the trust document. You are going to receive a gift. Maybe you're a child of the settlor and you were going to get an equal share, and now you're not. You're just completely excluded. The biggest problem that have-nots face is that you have to file a lawsuit to overturn the trust amendment or the trust that disinherits you, and you, as the person challenging that document, has what we call the burden of proof. A lot of people don't understand what the burden of proof is all about. They think, well, this is something my mother never would have done, and so all I have to do is go to court, talk to the judge, and the judge is going to overturn this bad trust amendment. But that's not at all how it works. What you have to do first is you have to bring a lawsuit, and you have to allege a legal ground to overturn the bad trust amendment, which usually is something like lack of capacity or undue influence. Those are the two most commonly used legal grounds to set aside a trust or a trust amendment. But the next thing you have to do is you have to go out and build your case using credible evidence. You have to go out and find that evidence, and you have to be ready to prepare it when it comes time for trial. Here's the problem you're facing as a have-not: that any document that is signed by the settlor is presumed to be valid under the law. That means the starting point is this bad amendment that disinherits you, that's presumed to be a perfectly valid document. And that's the presumption that you go into trial with. That means the people who are in favor of that bad trust amendment have an advantage because they don't have to prove anything. All they have to do is poke holes in your case, whereas you have the burden of proof. So think of it this way. It's kind of like if we were to play the Super Bowl all over again, but we give one team 3 touchdowns, that's 21 points, before the game even begins. So one team comes into the game with 21 points, the other team comes into the game with 0 points. You can see that the team coming into the game with 0 points has a disadvantage. They have to score 3 touchdowns just to pull even, and then they have to score even more in order to actually win the game. That's the burden of proof. You're the team with 0 points, and the people who are in favor of the bad amendment, they're the team with 3 touchdowns already on the board. So that's how the burden of proof works in our system. You have the burden to bring in credible evidence. How do you know when you have enough credible evidence? You never really know until the judge makes his or her ruling. And it ultimately is up to a judge, not a jury, because these are judge trials in trust contest cases, and they're going to decide your fate of your case. So have-nots really have a lot of work ahead of them if you're going to try to challenge a trust amendment or a trust and overturn it. How do you do that successfully? That's going to be the topic of our next video. Albertson & Davidson is here to help you fight for your inheritance. Check out aldavlaw.com for our complete library of helpful legal videos and articles from your favorite California trust and will litigation law firm, Albertson & Davidson, LLP.